right into this. Good. Let's get right into this. So there's a claim that basically happened, a classic lawsuit where the Social Security Administration, through Nancy A. Berryhill, who was the acting commissioner at that time, was essentially being sued. So the SSA, the commissioner, was being sued by Joseph Michael Green. Case number right here, 816 CV 2890 TDNF. Again, 816 CV 2890 TDNF. And what you learn from this particular case is that the people who you know, the people who you like, the people who you think will help you with knowledge about Social Security benefits, or maybe, might protect you from investigations, well, they don't always do that. And so I usually see two types of harms committed by family members or friends of actual disabled people. The first one is you will have essentially family members who think that they know everything about disability law, and they're going to tell you how it works and what you should know. And they were found disabled 20 years ago. And, they're becoming rarer and rarer because most of them are getting more educated. They realize the program has changed, yada, yada. But still, there's a few of them out there where they end up effing up a kid's life because they tell them all the wrong things for the disability benefits. And then the kid has to go through a bunch of appeals. And then they mess up the claim to the point where an attorney can't fix it down the line. And then you have to restart a new claim. That's the first kind. The second kind is basically when the police come out on behalf of the SSA, the OIG units, and they go ahead and begin the process of essentially questioning your friends, creating third-party witness statements. Now, a lot of people think their friends would not say things about them in a negative way to the police, but you would be surprised. Many of them do fold when interacting with the police because the police will usually come to them and they will create essentially what is called this zone of knowledge and this zone of help the community and this zone of fake friendship. Zone of knowledge. They'll know things and feed things to the person so that the person feels like they can't lie because their story won't match up with what they already have. And then there's this camaraderie for the community stuff. And then there's a camaraderie for basically, the friendship that you have with this police officer, this investigator on behalf of the Social Security Administration, the CDI unit investigators. Real quick, super thank you to Princess Diana for the $5 donation. I super appreciate that. That's absolutely amazing. She's one of our longest members, which is absolutely incredible. And also, Kosher, thank you for whatchamacallit. Reminder to extend your intro by 20 seconds as YouTube kicks off advertisements when you start video. Oh, okay. Well, that's good. I didn't know that. Kosher, that's really good to know. Kosher is our moderator. He does an absolutely amazing job. So it's just an incredible thing. So the bottom line is super thank you to Princess Diana and also Kosher as well. Now, what happens is because you have these two forces, right, acting potentially against you as a Social Security recipient, and it just doesn't have to be for disability benefits. It can be for retirement benefits of a claim of potential similar fault or fraud. It could be for SSI benefits. But what happens is you have these people surrounding you in your life. And the problem is that sometimes they will be used as daggers to your benefits because what happens? The statements that they create end up into what's called an ROI. An ROI is a report that is created by a CDI unit investigator. And the CDI unit investigator uses that report to present it to DDS. And DDS then adjudicates, well, and it could be the OHO too. It could be higher up the chain. But they adjudicate, they decide, they judge whether or not you realistically are disabled considering all the things that they've collected against you. Now, some of you argue, and I like that you do, that it seems like these OIG investigators that, follow you home, watch when you leave in the morning, it seems like they never seem to get video footage of you going into the trauma unit at the hospital or, going into basically the inpatient behavioral, institute or sanatorium or whatever. They always seem to catch you on the best day of your life where you're, skipping down the lovely walkway to your favorite, store to get a drink. I get it. And that's one of the problems that we learn and study in this particular case. And that's why I'm going to literally go through the entire case with you, because I think you need to understand specifically what the rulings are. And remember, we do these videos because way back in the day, I used to go around to the local, libraries in the county, and I would give speeches on how the program works, because a lot of people, they don't know, or they'd hear things that were wrong, or they'd have family members be found disabled way back in the day, or even a family member found disabled by a super liberal judge. And then whatever that family member did was like the word of God. And you have to understand, we do these videos so that you can actually learn what the law is, what the case law is, the statutes, the Social Security rulings, the policy guidelines, so that you can learn what they are, so that you don't get caught up in a lot of that negative stuff that ends up hurting your benefits. Let's go through it. Okay. So Joseph Michael Green, plaintiff versus Nancy A. Berryhill, acting commissioner of Social Security. They are the defendant. Opinion in order. Plaintiff Joseph Michael Green seeks, and remember, this was a district court, Middle District of Florida, Tampa division for this particular brief. And there's obviously more stuff before and a little bit after, but I picked this because I think it illustrates the best of what happened. Plaintiff Joseph Michael Green seeks judicial review of the final decision of the Commissioner of the Social Security Administration denying his claim for supplemental security income. So there's a guy, he applied for SSI, he went through all of the initial filing, reconsideration, ALJ hearing, appeals, he went through all of those, and then bottom line was, he essentially, he got denied through all of them, the entire SSA docket, and now he's going to the federal district court to sue the commissioner. Okay. Commissioner filed the transcript of the proceedings hereinafter referred to as TR, followed by the appropriate page number, and the parties filed joint legal memorandum setting forth their response positions, their respective positions. Remember, when you get to district court, when you leave the SSA docket and you go to district court, you create what's called basically a joint legal memorandum. And that's where you both write your positions into one brief. And that brief is then submitted to the court. For the reasons set out herein, the decision of the commissioner is reversed and remanded pursuant to Section 205G of the Social Security Act, 42 U.S.C. Section 405, subsection G. Now, what does that mean? Reversed and remanded. They don't agree with the decision, so they're sending it back down to the SSA adjudicators, AAJs, ALJs, to redecide the actual claim, okay? Now, some of you feel like I don't need to annotate these sentences, and then some of you feel like I don't annotate enough of these sentences. I'm trying to do my best. I know you guys throw me a lot of hate sometimes. You also throw me a lot of love. The love keeps me above, but man, oh man, some of you guys throw me some hate. But here's the deal. Okay, Social Security Act eligibility, standard of review, procedural history, and the ALJ's decision. Section A. All right, the law defines disability as the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairments which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months, right? Okay. They're just doing the 5-step sequential process elements for those who already know them. The impairment must be severe, making the claimant unable to do his previous work. Mild, moderate, severe. Severe is marked. Extreme. Severe is under extreme. Extreme is like bedbound. You don't have to be bedbound to be found disabled, but every year it becomes harder to be found disabled, so it feels like you have to be closer to that standard, okay? So the impairment must be severe, making the claimant unable to do his previous work or any other substantial gainful activity which exists in the national economy. Next one, standard review. The Commissioner's findings of fact are conclusive if supported by substantial evidence, which is ironic because this whole substantial evidence thing, district courts have aggressively gone after administrative law judges in the SSA docket because the substantial evidence that they claim is substantial is usually not enough for these district court standards. So these district court judges are reaching down to the commissioner saying, you need to create a better system because this is not okay. Because, a lot of you guys, who have been denied, you're like, hey, they didn't even bring up this doctor I went to. They didn't even consider their evidence. And that's part of the problem is that the SSA, especially during 2017, during Commissioner Saul, which is the Trump admin Commissioner Saul, they really changed a lot of the appeal rules, which made it significantly harder for people to appeal the claim and win the claim thereafter. So Trump in that regard was not a good thing for Social Security benefits. Just go ahead and look up the 2017 changes for appeals from Commissioner Saul. Okay. Substantial evidence is more than scintilla and is such relevant evidence as a reasonable person would accept as adequate support to a conclusion, right? So it is relevant evidence, right? Makes sense for the thing we're talking about. The conversation needs this type of evidence to prove it. As a reasonable person, you don't have insanity. You don't have schizophrenia. You don't have bipolar. You don't have anxiety, depression. You don't have PTSD clouding the potential of you having a reasonable objective opinion. And then you would accept as an adequate support to a conclusion, right? So you would line up the facts. This makes sense. It's enough to go ahead and provide for a conclusion that A equals B. Cool. Even if the evidence preponderated against the commissioner's findings, we must affirm, sorry, it's just tiny font. We must affirm if the decision reached is supported by substantial evidence. That was Crawford v. Commissioner. Okay. In conducting this review, this court may not reweigh the evidence or substitute its judgment for that of the ALJ, but must consider. Okay, so what they're saying there is they can't just take the evidence and like redo the claim, right? They're not there to redo the claim. They're there to see if the judge made an error as to law or fact. They're not there to see if the person is disabled in the traditional adjudication of that sense, right? Because when you're at the district court, the legal standard changes. Okay, so in conclusion, this review, the court may not reweigh the evidence or substitute its judgment for that of the ALJ, right? So they can't decide if you're disabled just like the ALJ, but must consider the evidence as a whole, taking into account evidence favorable as well as unfavorable to the decision. So they use the totality of the circumstances legal doctrine to look at all of the different evidence and see if it was properly applied. Okay. So in other words, what they're doing is they're fact checking and law checking the judge to see if that decision was actually correct. Cool. All right, next one. That was Martin v. Sullivan. However, the district court will reverse the commissioner's decision on plenary review if the decision applied incorrect law, or if the decision fails to provide sufficient reasoning to determine the commissioners properly applied the law. Okay, so remember, if they get the facts wrong, if they get the way that they apply the law wrong, if they get the law wrong, then they can reverse the decision. Okay, so that was that was Keaton versus Department of Health and Human Services. The court reviews de novo like new. The court reviews de novo like they're just seeing it for the first time. The conclusions of law made by the Commissioner of Social Security in a disability benefits case. Okay. So they look at it like brand new. They're not like tainted by the history of it. I mean, nothing's perfect. They're all humans, but they look at it de novo. They look at it from a very new perspective. Now, the ALJ must allow 5 steps in evaluating a claim of disability. The 5-step sequential process, the basic elements of disability. I do not know why they do not teach the 5-step sequential process in many of the courses they teach to advocates who work for counties and local mental assistance facilities. I don't know why. They just like, that's where you would start. Like if I were teaching a course to like advocates, I'd be like, these are the elements. This is where you start. Instead, they're like, these are the forms. But I don't think I think you should start with the legal doctrinal theory as to how it actually works. Although maybe, you know what, maybe I'm not, maybe I'm wrong. You know what I mean? But I went to law school. In law school, you have to be hyper intelligent to be competitive and stay in. So, I mean, maybe just learning the forms is good. I don't know, whatever. The ALJ must follow 5 steps in evaluating claim of disability. At step 1, the claimant must prove that he is not undertaking substantial gainful employment. You're not earning more than $1,620 per month. Cool. If a claim is engaging in any substantial gainful activity, he will be found not disabled. So if you're earning over SGA, substantial gainful activity, $1,620 per month, guess what? You're not disabled. Cool. At step 2, the claimant must prove that he is suffering from a severe impairment or combination of impairments. Okay. So basically step 2 is just your impairment has to last 12 months. I'll read the rest of it to you, but just your impairment has to last 12 months. If the claimant's impairment or combination of impairments does not significantly limit his physical or mental ability to do work activities, the ALJ will find that the impairment is not severe and the claimant will be found not disabled. But other courts have ruled that basically the whole point of that is you have to have a severe impairment that's lasted 12 months. Okay. At step 3, element 3 of being found disabled, the claimant must provide that his impairment meets or equals one of the impairments listed. So they've got a big list of impairments. And if you meet, equal, or exceed, if you're worse than one, equivalent to one, or similar to one, right, of these listed severe impairments, then you can be found disabled on what we call a listing, because it's a bunch of listed impairments, right? Anxiety, depression. Well, technically depression comes first, but depression, anxiety, schizophrenia. Well, technically, schizophrenia isn't. You got bipolar, panic attacks. You got PTSD. You've got intellectual disorders, etc. You got all kinds. Okay? So, step 3, the claimant must prove that his impairment meets or equals one of the impairments listed in 20 CFR point 404. Cool. Okay, and that's okay. If he meets this burden, he will be considered disabled without consideration of age, education, or work experience. So, in other words, what they're saying is on the 5 elements that make up disability, real quick, element 3 has a magical little door where you can be found disabled right at element 3 and not have to go basically to element element 4 and element 5. Okay. So let's see. And let's see. Oh, good. We have a person that's insulting me and trying to be mean to me. Barbara Yohem. Thank you so much. She said, thought you were an attorney. Isn't your job to maintain legal action, not contributing to fraud? I don't see how pointing out to people how fraud works and what you can learn from case law about how fraud is committed. I don't really see that as contributing to fraud. I think you might have a misunderstanding as to the basics of how people learn to protect their benefits and not commit crimes by knowing what the crimes are. So we'll just keep rocking and rolling. So, all right, at step 3, the claimant must prove his impairment meets, equals, or exceeds one of those listed impairments. If he meets this burden, he'll be considered disabled, and they don't care about the other stuff. So it's a cool little magic door. It gets you to the next thing, okay? At step 4, if the claimant cannot prove that his impairment meets or equals one of the impairments listed in Appendix 1, he must prove that his impairment prevents him from performing his past relevant work. All right, so let me break this down. If you're not as severe, if like one of your impairments is not severe enough as one of these listed impairments, which most of you are not, okay? So if you're not as severe as one of these listed, remember, the listed impairment for an amputee is they have to take both your ankles down or both your wrists and down, so you're missing both your hands, or your entire leg and half your hip. They are severe. They are severe for a singular impairment. So when people are like, oh, I just need to go to a doctor and tell them I have anxiety and then boop, I get benefits. Those people, look, 20 years ago, you could go to a doctor 3 times and get a liberal judge and get approved. That's not how it works anymore. It hasn't worked that way for a long time. Okay. But those people still exist. They're out there. They just, they're not mentally all there and they don't understand what's going on. And that's okay too. That's okay. So the bottom line with this whole thing is step 4, if you're not as severe as one of those listed impairments, they say, all right, well, your one impairment ain't enough. But if we take all of your impairments combined, we combine them into a ball and say, if this person carries this ball of all of these impairments, remember how I always teach you, what are your top 5 impairments? When did each begin? When did each become severe? What are 2 symptoms for each? As they're training questions. They're training questions, which ironically, a lot of people can't answer about their disability benefits. It's weird. I get claimants from big box firms and I'm like, what are your top 5 impairments? They're like, I don't know. Like you're literally, your life is hanging on a thread on that particular thing alone. Like, but the point is, in element 4, we take all of them, we put them in a ball, and we say, could this person carrying this ball of impairments through their life be able to work at the simplest, most basic full-time jobs in the national economy? Right? That's what we do. That's how we do it. Okay, so at step 4, if the claimant cannot prove that his impairment meets or equals one of the impaired listings, he must prove that his impairment prevents him from performing his past relevant work, which is work you've done within the past 5 years. Can you do the jobs you did in the past 5 years? At this step, the ALJ, the judge, will consider if the claimant's RFC, walking, standing, pushing, pulling, lifting, crouching, stooping, kneeling, blah, 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 and then all the mental ones. The ALJ will consider the claimant's RFCs and compare it with the physical and mental demands of his past relevant work. So considering you got all these problems, you got this ball of list of impairments. If you had to carry that ball to work, would you be able to do the jobs? Sorry, I actually sprained my elbow. Would you be able to do the jobs within the past 5 years that you did with this ball of impairments that you now carry with you? Cool. So that's element 4. Element 4 is, can you do your past relevant work? We call it PRW. can you do the work you once did? Next one. At step 5, that's the cleaver. That's the one that just beats you down. Now remember, when SSA is reviewing you for the first time, they're going to use the 5-step sequential process. When they're reviewing you the second time through a CDR, they use the 8-step sequential process. I'm not going to go through that whole thing in this video because I want to get to specifically what the investigators, how they watch the person, who they talk to, who basically spilled the beans on what the capabilities of this person actually were. Okay, I want to get to that. So let me just finish this real quick because you got to know how this works first. Okay. All right. Next thing. At step 5, the burden shifts to the commissioner to prove that the claimant is capable of performing other work available in the national economy, considering the claimant's RFC, age, education, and past work experience. So now they're saying, all right, look, we don't think you could do your past work. You were a scientist at NASA. You are a professional basketball player. You are an ice cream cone sprinkler, a person who applies sprinkle. I don't know what do you call that? A dipper? An ice cream cone dipper where you put the sprinkles on it? I'm not really sure. We'll just call them a sprinklet. That doesn't make any sense. We're going to move on. The point is, right, you can't do your past work. So now we ask, could you do any other job out there in the national economy? And then they take this big book and they open it like a Harry Potter moment. They're like, and you can hear the whole room just gets like really quiet. And then the pages just start flipping and flying back and forth. And then they go, a job. And they look at it and they go, yes, this job, this person could do this job. And that's where the vocational expert will come in and say, yes, Your Honor, I have these 3 jobs available. And then the judge will go, I'm going to give you another hypothetical. What if the person can do this, and this, but can't do this? And then that magical book starts to throw pages back and forth. And then the vocational expert goes, aha! And he puts his finger right on the book and says, right there's 3 more jobs, right? So they go through this back and forth, right? About jobs in the national economy that you could potentially do. And these jobs are very easy jobs, like, addressing envelopes, blanching almonds, although they don't like to use that one anymore. And that's step 5. Step 5 is a cleaver. Like that cuts off a lot of people from getting benefits. Step 5 is, and remember too, like that's where they tend to cut off a lot of people who are under 50. That's like a right there. Next one, step 5, the burden shifts to the commissioner to prove that the claimant is capable of performing other work available in the national economy, considering the claimant's RFC, walking, standing, pushing, stooping, kneeling, crawling, age, 20 years old, 40 years old, 60 years old. Education, I finished 6th grade. I finished 12th grade. I finished 3 years of college. I finished a doctorate, right? And past work experience. I used to work as the manager of Widgets Incorporated. I used to work as the executive vice president of Widgets Incorporated. I used to work as the owner of Widgets Incorporated. I used to work as the person who licked the stamp that went on Widgets Incorporated products, okay? Right? Work experience. That's by, okay, good. If the claimant, I'm not going to say all the case names that it comes from because I don't feel like you're going to look them up anyways, but it's just, these all come from case law. If the claimant is capable of performing other work, he will be found not disabled. Or put it another way, if you could do a simple, super simple SVP1, SVP2 job, right there, the bottom line is you're not found disabled because they're going to say, go get that job. Even if there's none of that job in your state, right? They can still be like, okay, go get that job 4 states over. They expect you to magically move, even though you're impoverished and about to be homeless or already homeless. Not a perfect system. Okay. So in determining whether the commissioner has met this burden, the ALJ must develop a full and fair record regarding the vocational opportunities available to the claimant. Allen v. Sullivan. They don't really do that. They do it quasi, but they don't really do that. When you're like, oh, okay, what can this person actually do? That's why they send you to CEMEs, where you see their doctors, and their doctors give a vocational assessment, even though they're medical doctors. That's why they do that, because the doctor is outlining what you potentially could do. And that's where they F people over, because when you go to your doctor is not allowed to proffer to proffer. Oh, Leanne, I see your thing there. Leanne, just text me later, call me later. Just remember, I'm going on my first date in like 8 years. So just realize, like, I'm going to be focused on that. I'm going to be like, this date should go perfectly because blah, blah, blah. So just be aware. But Leanne, yeah, shoot me a text. No worries. Ask me a question. So with that said, there are two ways in which the ALJ may make this determination. The first is by applying the medical vocational guidelines, the grids. And the second is by using a vocational expert. That's Phillips B. Barnhart. Only after the commissioner meets this burden does the burden shift back to the claimant to show that he is not capable of performing the other work as set forth by the commissioner. So they got to figure it out. They got to figure out whether or not you can do these other jobs. They got to figure out whether or not you fit into this grid system. Grid system just means if you're over 50, 55, or 60, there's ways to be found disabled that are a little bit easier than a vocational allowance through a vocational expert. Now we're getting to this specific case. And this case is very important. I don't want you to mess it up. I want you to listen to this part because this is the procedural history. We're going to get into literally, we got this page and then boom, right there, we get into who snitched on our claimant, the disabled person. Procedural history. Plaintiff protectively filed an application for SSI on September 17th, 2012. Okay. Alleging disability beginning January 27th, 2007. Okay. So he filed for benefits 2012. He claims his impairment started in 2007. Plaintiff's application was denied initially on February 5th, 2013, and upon reconsideration on May 9th, 2013. So he's got a denial at initial filing and a denial at recon. He's going to the judge. Plaintiff requested a hearing, and on December 1st, 2014, an administrative hearing was held before Administrative Law Judge Margaret Craig, the ALJ. Okay, so 2012 he files. February 2013, he gets his first denial. May 2013, he gets his second denial. And then December 2014, he goes in front of an administrative law judge. And that's how it worked back then. You could literally get denied or approved within 3 to 6 months. Not like today, where it's like 15 to 19 months. No. But back then, that's how it worked, when the system still worked. An administrative hearing was held before Administrative Law Judge Margaret Craig. A second hearing was held before the ALJ on March 11th, 2015, and the ALJ entered a decision finding that the plaintiff was not under a disability from September 17th, 2012, the date plaintiff's application was filed. Plaintiff filed a request for review with the Appeals Council. They denied it on August 15th, 2016. Plaintiff initiated this action by filing a complaint on October 12th, 2016. Okay, so plaintiff got denied an initial filing, reconsideration, ALJ hearing, Appeals Council, and now he's filing and suing the commissioner of the SSA in district court. Summary of the ALJ's decision. At step 1 of the sequential evaluation, the ALJ found, remember, step 1 is, are you working over $1,620 per month? But that's for 2025. Back then, it was way cheaper. It's probably under $1,000. At step 1 of the sequential evaluation, the ALJ found that the plaintiff had not engaged in substantial gainful activities since September 17th, 2012, the application date. So since 2012, he hadn't been working, he hadn't been earning anything at or basically above the SGA amount. Hold on, I'll tell you what it is. Hold on, 2012 SGA amount. I'll tell you what it was. It was okay, there you go. So it's just above $1,000, $1,010. So $1,010, he wasn't earning at or above 1,010 buckaroos. Okay. At step 2, the ALJ found that plaintiff had the following severe impairments: degenerative disc disease of the cervical and lumbar spine, seizure disorder not otherwise specified, neurocognitive disorder not otherwise specified, and substance abuse disorder. Yeah, that was back in the day where, like, you could work with a judge, talk about future plans to get them approved and, still go forward. But, a lot of substance abuse disorders, a lot of those just get summarily, not summarily, but they get denied pretty darn easily. At step 3, the ALJ found that the plaintiff did not have an impairment or combination of impairments that meets or medically equals the severity of any of the listed impairments in 20 CFR Part 404. And that's true, but you have to keep in mind, you have to think of that one impairment, because most of these impairments equate to essentially that listed impairment. They can combine other ones to say how they make it worse to be similar, but it's usually more easy to think about it as a singular impairment with add-ons or things that attach and boost it. But again, we're getting in the weeds here. This is the part right here where they talk about essentially some of the things that the claimant claimed and how he was, limited in doing things and yada yada. And then we go into basically the four persons who stabbed him in the back. Okay, so here we go. Okay, so the step 4, they gave out an RFC as to what they thought his capabilities were. Step 5, ALJ relied on testimony of a vocational expert. They found that basically he could be a small parts assembler, he could be a polypacker, heat sealer, and a final inspector, right? So they found he could do these jobs. Plaintiff raises 2 issues on appeal. Whether the ALJ erred by considering the CDI investigative report. So the plaintiff is saying, you guys sent a person to watch me, to interview people I know, and you shouldn't have been able to do that. That's his first argument. His second argument, whether the ALJ erred, made a mistake, by failing to properly develop the record, the court will address each issue in turn. Okay. Whether the ALJ erred by considering the CDI investigative report. Now, focus on this part, because this part is going to tell you who stabbed this guy in the back and why this is going on, and consider all the options here, who snitched on him, all that stuff. The record shows that the ALJ entered into evidence a cooperative investigations unit report. Cool. That was completed by the Cooperative Disability Investigation Unit on January 20th, 2013. So remember, 2012, right? He was getting an initial denial at initial filing, another denial at reconsideration. Around 2013, he was going to the judge. So around 2013, while he was waiting to go to the judge, they sent out an investigative team, a CDI unit, and that investigative team was following him around to go ahead and see if he truly was the disabled person that which he claims he actually is. So my point to you is, at any point of the application process, they could potentially send out investigators to watch you. Okay, that's exactly what happened to this guy. The investigation was initiated at the request of a supervisor from the Tampa, Florida Division of Disability Determinations based on disparities in the available evidence, which prompted suspicions that plaintiff was exaggerating the severity of his functional limitations. They thought he was a fibber, so because they thought he was a fibber, they sent out a crew of people to go and basically watch him, talk about what they've noticed of him, etc. The investigation was conducted by a financial crime investigator with the Florida Department of Financial Services, detailed to the Tampa CDI unit, who visited local establishments within the vicinity of plaintiff's listed address, showed the witnesses a photograph of plaintiff, and spoke with individuals believed to have knowledge of plaintiff's actions and abilities. The synopsis of the report provided that 4 persons, so there were 4 of them, believed to be familiar with Green's actions and abilities, described him as being essentially unimpaired, both physically and mentally. These witnesses described Green as a regular customer who shops alone at 3 separate convenience stores. So what are we learning? When you are disabled and claiming that you're disabled and you go to a convenience store, they're gonna interview the convenience store people, because they're already going to be following you around to see which stores you go to. So the convenience store people are on the list of your buddies that you interact with that they're going to go ahead and interview. So these witnesses describe Green as a regular customer who shops alone at 3 separate convenience stores. He frequents one store on an almost daily basis and the other 2 on a weekly basis. Now you must be wondering, look, 2012, 2013, 2014, 2015, 2016. How the hell do you survive all this time without an income? And why is he going to the store all the time if he doesn't have money? Right? You starting to see it? Okay. One witness reported that Green usually walks to the store, and another witness reported Green drives a sand-colored truck. The witnesses have never seen Green use any type of assistive device or display and gait disturbances. Green makes good eye contact when speaking, shops independently, and makes his purchases with cash. See that notation? Makes his purchases with cash. Because remember, to investigators, if you're using cash, that to them usually means that, you're trying to hide something, which sometimes people are. It's just, to be fair, it is the way it is. Now, I want you to recognize here, these are shop owners that were his buddies that he talked with, that he visited on a daily basis, yada, yada, yada. it's usually the family members who will snitch on other things. How much time you spend playing video games, whether or not you're actually taking medication or just getting prescribed it and saying that, you take it, but you're not actually taking it. Because, they take these things seriously. Like, if you've got a back issue and you're playing video games all day, then how are you sitting that long? Why couldn't you do a job? If you're getting prescribed medication to validate, your impairments, then they expect you to be taking that medication. Because, you get some people where they're like, you know, I don't need medication, blah, blah, blah. Those people live in la la land. But the reality is, in order to show that you're impaired, they're going to look at what are your symptoms, what are your signs, what are your medications, what are your side effects, how often do you go to the doctor, how many specialists do you have, how many times have you had to have critical treatment, crisis treatment, emergency room, behavioral center. Those are the basics of what they look for. Okay. Further, the CDI report indicated plaintiff had been cited by several traffic offenses since 2010, including obstructing traffic, crash and leaving the scene of a crash. Obstructing traffic in November of 2010, crash and leaving the scene of a crash March 2012, and failure to pay a traffic fine September 2012. The person also indicated plaintiff's driver's license was revoked as a financial responsibility suspension relative to insurance and a crash. So in other words, this guy's driving around all the time. If he's driving around all the time and he's got all these impairments that he's claiming, well, if people can drive, that requires a lot of capability. You got to be able to look at the mirrors. You got to be able to have good eye-hand coordination. You got to be able to deal with quick problems that pop up. You got to be able to get in and out of the vehicle. So standing seated, you got to be able to deal with bumps. Got to be able to deal with high-speed movement. Got to be able to deal with all this stuff, right? So a lot of disabled people, they don't drive anymore because they don't trust themselves because they don't want to die. Some people are like, I'm just going to keep driving because it's what I do. I got my check and everything's good. They investigated this guy in 2013, and their investigation system was very small back then. Remember, a lot of the CDI unit stuff came as a result of what was adjudicated fraudulent firefighter and police officer actions in 9/11. That's where it really got its money going. That's where it really got built up. That was 2001. 2010, 2011, 2012, 2013, they're rolling. But nowadays, they got way more CDI units, way more investigators, way more of this stuff. They're even in other countries now investigating people, like Indonesia. Okay. All right. At both the first hearing and at the supplemental hearing, counsel for plaintiff objected to the introduction of the CDI report into the record after the ALJ asked counsel if he had any objections. The ALJ provided no reason at the hearing or in her decision for overruling the objections. In her decision, the ALJ addressed the CDI as follows. Thereafter, the Tampa CDI unit conducted an investigation for the purpose of determining the claimant's true level of functioning. The claimant was witness to shop alone at the 3 separate convenience stores. He apparently frequents one of these stores on a daily basis and at the other 2 on a weekly basis. He was observed to drive a sand-colored truck. He apparently does not use an assistive device or display any gait disturbances. He reportedly makes good eye contact when speaking. That's when they do an assessment as to your mental capacity. When speaking, shops independently and makes purchases with cash. One witness reported that he selects his own items on the floor, normally beer, and asks for cigarettes once he approaches the counter. On one occasion, the claimant was reportedly angered within a business when an associate accused him of shoplifting. The claimant apparently strongly verbalized and told the associate to come outside so he could physically rectify the situation. Right, so we got a sweet guy who hasn't been working for years and years and years, who somehow has money to buy booze and cigarettes, who basically might be shoplifting a little here and there, and has some buddies at stores and has some frenemies as well. In addition, the ALJ noted the claimant stated that he does not drive, relies on his wife for transportation, and he had to surrender his license after he began having seizures. Yet the CDI reported dated January 2013 shows the claimant was observed to drive a truck in spite of having his driver's license suspended indefinitely in December of 2012, right? Because he had all those car accidents and car problems. So it appears on its face, we are not dealing with somebody who is genuine. We look like we're dealing with somebody who is disingenuous, who's trying to manipulate it. One of those types that's like, I know how it is. I'm just going to say this and do this and blah, blah, blah. And that's fine. There's a lot of people, when it is what it is, The reality is sometimes when a lot of people, and I'm going to say this, and some of you will disagree, sometimes people get in trouble and then they get more trouble, and they get more trouble, and then they live their life from the it's effed reality. And when they do that, the trouble just keeps coming back to them. And I'm not saying that they shouldn't keep running from the trouble and they shouldn't keep saying things to try and make their situation better. Everybody's going to try to make their situation better no matter what. But what I'm saying is, at the end of the day, this is not uncommon for a group of society. It's just not. I work with the homeless all the time. I see that stuff all the time. Okay. Plaintiff argues that the ALJ erred by admitting the CDI report into the transcript and by considering the report in making her decision, while acknowledging that an ALJ may receive evidence at the hearing, although the evidence would not be admissible under the rules of evidence used by the court. Plaintiff contends that it was erroneous to consider the report given that it contained nothing more than statements concerning plaintiff's physical and or mental capabilities from unidentified, unnamed witnesses who were shown an unauthenticated photograph, which was purportedly of plaintiff. And it's a good argument, right? The attorney saying, hey, we don't know who these witnesses are. We don't know what shops they're necessarily part of. We don't know if somebody just made this up. We don't know. Now, of course, somewhere inside their system, they've got a whole write-up of statements made, a recording of what the statements were on camera and audio and yada, yada. But again, the report didn't include that information. So objecting to the report coming in is a way that a lawyer would say, we don't want the report because we can't see. You're hiding information that I would need to object to. Plaintiff notes that the witnesses were never identified and purported photograph of plaintiff was never offered into evidence, and that there seemed to be no effort to produce even the author of the CDI report, making the CDI investigator present for the hearing. Plaintiff argues that the CDI report was provided to multiple physicians and that the report tainted their findings and opinions. Not a bad argument, right? The report says the claimant's a liar. The report says the claimant's a drunk. The report says the claimant's a cigarette smoker, a chain smoker. Not a bad argument. It obviously taints what people are going to be reading about this person. In response, defendant argues that the ALJ properly admitted into evidence and considered the CDI report without infringing on plaintiff's due process rights. So the SSA is going to say that they brought it in, it was proper, they should be allowed. Defendant, the SSA, contends that the ALJ admitted the CDI report into evidence pursuant to SSA's program operation manual system and properly considered it, along with other evidence, in making her disability determination. Defendant argues that plaintiff failed to establish prejudice resulting from his inability to cross-examine the CDI investigators or witnesses. Further, defendant argues that the ALJ's decision does not rely exclusively or even heavily on the CDI report, and that remand would not change the ALJ's overall determination. I always hate when the judges make this argument because I think it's total and complete BS. You bring in a report that you send to doctors of the SSA who read it that become biased. Then the judge claims down the line that she made a decision based off of those doctors' decisions. Then after that, the judge goes, I didn't really even use it or heavily consider it for my adjudication. I just, it was there. It was there, but I didn't really think it was that important. It's such BS. You know what I mean? When the judges play that game, it's just total BS because the ALJ's decision does not rely exclusively or even heavily on the CDI report, and that remand would not change the ALJ's overall determination. Oh, okay, sure. So you used it all the way up to this point completely and utterly, but now that's being called into question. You didn't use it heavily. You didn't rely on it heavily. You didn't rely on it exclusively. Okay, all right. Here we go. The SSA's Program Operations Manual, POMS, addresses the use of CDI reports and disability determinations, POMS DI, entitled Disability Hearings, Use of Cooperative Disability Investigations Units, blah, blah, blah. Okay, the report of the investigation evidence provides that here we go, here's the thing, majority of an ROI is a report of third-party interviews by highly skilled interviewers. And that's true. They get people that are in the industry of interviewing. Consider the reports, weigh with the totality of the evidence, and evaluate to determine whether, and to the extent to which the other evidence supports the reports, the ROI helps you to evaluate the credibility of a claimant's statements. Surveillance information in both video and narrative form can provide snapshots of a claimant's observed functional ability. We consider this information with all the other evidence to reach conclusions about the claimant's medical impairments and material to the determination of whether the claimant is disabled if the claimant is able to work on a substantial basis. So the problem is we allow our government to follow us around to tell us whether or not we're disabled. And then when they don't provide us information about what the investigation should provide into the evidence system, the F folder, when they don't provide who the investigator was, when they don't provide who the witnesses were, when they don't provide the media used to talk to the witnesses, when they don't use that stuff, and they don't show that, or when they use it and then don't show it to us in the report, it's a problem because we don't have the opportunity to properly defend ourselves because we just haven't received proper notice during a proper adjudication. And that's a problem. That's a constitutional issue. The POMS also addresses disclosure of confidential information, noting that the ROI is sanitized to protect the identity of the confidential informants, investigative techniques, or remove other information that can be properly withheld under the Privacy Act. So the government hides. The government goes, well, we need to protect the names, the locations of these witnesses so that something doesn't magically happen to them during this adjudication process. Because you know it as well as I, if somebody did this and that guy has all the time in the world and he visits these shops frequently, that guy's going to know exactly where to go, what to do, what to yada yada. So he's going to know. But in the report, they pulled back that information. Although the POMS broadly provides that an ALJ shall consider CDI reports, in this case, the court finds that it was improper for the ALJ to have admitted the CDI report at issue into the record. As plaintiff aptly summarizes, the CDI report contains unverifiable statements. Exactly. The hell is that shit? You gotta know. You gotta know. This isn't an HOA board where everybody owns a house, but in reality, an HOA owns your house and your butt, and they get to decide who does what, and they get to tell you who snitched on you and who doesn't, and then they always withhold that information. This isn't an HOA. This is the federal rule of law. This is district federal court. If somebody's going to point their finger at you, then you have the right to defend yourself from that person. As plaintiff aptly summarizes, the CDI report contains unverifiable statements from unnamed witnesses who were shown an unauthenticated photograph purportedly of plaintiff. Despite plaintiff's counsel's objections at the first and supplemental hearings, the CDI report was entered into evidence and no mention of the objections was made in the ALJ's decision. Further, the author of the CDI report was never produced at the hearing, and the purported photograph of the plaintiff was never entered into evidence. So in other words, they got to supply evidence to show it, and they got to bring the investigator in during that actual process. An ALJ may receive evidence at the hearing, even though the evidence would not be admissible in court under the rules of evidence used by the court. Remember, for disability hearings, they're allowed a lesser standard of admission of evidence, okay? Kind of like VA hearings. And the reason why is if people, like disabled people, had to actually follow proper evidentiary standards in civil procedure or criminal law, like nothing would ever get submitted because they would never be able to functionally get the evidence in that pure form to get it submitted to the court. So they have to use this lessened standard to allow people to submit evidence, okay? Nevertheless, given the ALJ's failure to provide an explanation for overruling the objections, the court finds it was erroneous for the ALJ to accept the CDI report at face value, even though she didn't highly lean on it. And even though she didn't, even though if you took it out, it wouldn't have affected anything. What total BS is that? That's always like, I'm like, come on. The court rejects defendant's argument that plaintiff the court rejects the defendant's argument that plaintiff has failed to show that he was prejudiced by the ALJ's admittance of the CDI report into the record. The ALJ discussed the CDI report at length in her decision and relied upon it in finding plaintiff's complaint not entirely credible. Further, as plaintiff notes, the CDI report was examined and considered by numerous physicians whose findings the ALJ relied on. Because, yeah, let's just be fair here. Let's be realistic here. And when you put a report like that into the record and you send it to experts, the claim is biased forever and ever going forward. until of course, he has to refile and they wipe that thing out of the record unless the judge pulls it back. There's a little of that too. Upon remand, the ALJ shall reopen the case for hearing, directly address plaintiff's objections concerning the CDR report, develop the record as necessary, and conduct any further proceedings as appropriate. So the point of this is they will interview people. First, they get a photo of you to take to them. They use that photo to say, do you know this person? Can you tell me about this person? Then they create a report. The report has to have who's pointing the finger at you, who's snitching at you. The report has to have who was the investigator, because you have to be able to request that they be present for the hearing. Okay. And also, to be fair, you have to be able to have some time to review it, read it, to establish a proper defense. Otherwise, they're just like, now the SSA is not known for giving proper notice like that. If one of the weakest things the SSA would be like weak at would be giving proper notice to people about things they did. In fact, the OIG on behalf of Trump stepped down specifically because a whistleblower said, hey, look, in their office of OIG, the Office of Inspector General, the whistleblower said, hey, look, we're sending the SSI people these notices that they have overpayments. We're not giving them enough information to figure out what's going on. And then we're doing, we're taking their benefits. And we're saying we're going to take this much benefit away from you going forward. And remember, during Biden's term, it was 100% taking of benefit unless they negotiated a deal, submitted a 632 and got a waiver or a reduction, or basically they did like a percentage reduction. It was only until Martin O'Malley got in, who I really like, it was only until he got in that they reduced it down to 10% taking of your benefits. Okay. So what did you learn from this claim? In this claim, you learned that friends, family members, shop owners, people who see you walking around, people who know you. And remember, there's that little area of like people who hate you that are going to seem biased in court. They got to be careful with those, right? Because they have a reason to go after you. And then you have friends and family. They're supposed to be taking care of you, right? And then in the middle part, there's that little group of people that represents essentially those people who don't really have a dog in the fight. They don't really care. They would be the most unbiased in this situation. They make great witnesses. But again, going back to the basic theme, people who hate you, people who want to sabotage you, and those people have to watch it. Because remember, there's a lot of rules and regulations where you as a person are protected from harassment, from false statements, from false claims, from false writings. So, those people, I've always noticed this, like, I don't really know what the deal is with this, but for some reason, like at the end of the day, people who want to hate you, they feel like they can just throw your name into the dirt and drag it behind the carriage for 20 miles. They don't realize that they can get sued for all of that. And I think what's happening is there's like two ways that people get in trouble with that. It's either that they're sued or they're canceled. Canceled is like the civilian version of getting sued for fraud, defamation, libel, etc., stuff like that. So, the thing is, if you're ever sitting there, you're like, I might report this disabled person, blah, blah, blah. Just make sure you actually know what you're doing and what the facts are before you do it. Now, other side of the coin is you got the family members. Family members sometimes talk to the police. They don't realize they just said something that's going to kill your claim. It is what it is. Unfortunately, some of the worst enemies of people trying to get benefits are their friends and their family members, because they're going to tell you how to magically win, F it all up, and then you'll be farther down and the attorney won't be able to take the claim and fix it, and then you got to kill the back pay. So it's a problem. All right. With that said, now you know how they do this process. They follow you around, they take a picture, they print the picture, they go investigate and ask people about what they've noticed about you. They get their statements on file, and then they put them into the report. But that file, when it goes into the record, has to have who those witnesses were. It has to have who the investigator was. You have to be able to bring the witnesses or the investigators forward, and you have to be able to go ahead and have time with proper notice to establish your defense. Okay? I hope you enjoyed this video. We only got a couple of likes in here compared to the amount of people watching right now. Please hit the like button. Hit that like button. Give it a good, strong liking. Also, with that said, subscribe if you want. I always appreciate people who subscribe. Another thing that I really enjoy is if you go to Google, you type in Disability Resolution or Disability Resolution Florida, throw some stars up there on the company. I always appreciate that. It gets me excited in the morning, but it's up to you. Also, please remember Mondays and Thursdays I go live to answer questions for free. So bottom line is we're going to be doing another video, and then I'll go live and answer questions for a short session. Because remember, I have a date later today, and that's important to me. I haven't been on a date in forever, so this is like important. So let's get it right. Let's focus. So with that said, also, if you have like a bigger question of something, you're not sure how to fix something, you're like, you can't find an attorney to fix it, there's a 1-hour private session contract below. You can always use that. Sunny D, Badoop Badoop. I love that name. Sunny D, Badoop Badoop. That's like I don't know, that's like a rock anthem right there. Sunny D. All right. So anyways, I will catch you guys a little bit later. Thank you for the $5 donation. Love the little fox right there. Have a wonderful, wonderful day, and I will be back in about 5 minutes. I'm going to grab a soda real quick, and we will rock and roll from there. Attorney Walter Hnot, the most viewed and subscribed to disability attorney in America, most clicked on. I will catch you in the next video, and we will have a good time. Thank you so much, and we'll go from there. Bye-bye, everybody. Bye-bye.